Hello, hello. Welcome to my channel. This is attorney Carmiece Graves. As stated above, I practice family law and estate planning in Washington, D.C. and Maryland area. And this video today, I'm focusing on estate planning, and a special demographic near and dear to my heart is women or single people who don't have kids, not married, or, really need to think about who may be available for long-term care and to deal with your estate when you pass along. So hold on one second. I just need to make sure that the Instagram part of this has done what the Instagram part is supposed to do. And I don't know if I got that to work, but it says I'm okay. So I'm gonna just leave it as that. So welcome again. So listen, this topic is near and dear to my heart. My shop is divided into two segments. Dealing with estate planning, I tend to think about, women that have amassed, assets over their lifetime, maybe married, maybe divorced, may have kids, may not, but typically maybe not. And what I found is this demographic has to do more with regards to planning, more thoughtfulness, just because it's not by default that you have a spouse that's going to take over or you have kids that are going to take over. It's all about redefining family. So this is about just redefining family for yourself, redefining it in terms of who will be there to support you, who will be there to step up and help take care of you. So part of this is personal. Obviously, I'm thinking about it for myself, while I'm thinking about it for my prospective clients. And I'll tell you, one of the roles that I play as a estate planning attorney in Prince George's County is I have the honor and pleasure, it's kind of like my give back to the community, to be appointed as guardians. I get to be a court-appointed counsel when people file for guardianship. So first off, I want to briefly give you an overview on what the guardianship proceeding is all about, why you should care about it, how it can impact you, and then what we can do to plan around that. Because going through this, sometimes you kind of see things, and the purpose of these videos is just to share some insights with you. I have a unique lens as an estate planning and family law attorney, and there's things that I just wish the community knew, things that I would like for you guys to be mindful of. I understand that estate planning sometimes is not the most enticing topic, and it's something that you can be frozen by fear. Okay, you know that fight, flee, freeze. Sometimes estate planning, because you have to reconcile for yourself that what happens to you when you pass away is a glorious experience. Until that's reconciled, a lot of times, especially in the African American community, we don't do a lot of planning because there's been a lot of fear involved with what happens after, right? So people don't want to think about after. They will just think about now. But sometimes that now could be, tomorrow very soon, and, involve your long-term care. Also, I'm at the stage too. Good afternoon, Harriet Williams. That's my mom. She always checks in. Thank you. And we have somebody else on the line. Buena Bonita. Thank you for joining me. Thank you so much for tuning in to talk about this topic, or be with me as I go through it. So also in that space of, as I'm making this video, I'm 48 years old, meaning that I'm super grown. So my perspectives now change a little bit. I'm thinking about taking care of others, loved ones, friends, family, things of that nature. I'm getting into that caretaking age as well. So the thing there is, guardianships are the process by which someone has petitioned the court because you, or say the alleged disabled person is in need of a guardian, and that guardian needs legal authority to take care of their finances, take care of the decision making. And what that means, the thing that tells me first and foremost when that happens, is that there are no estate planning documents in place. Okay, so someone did not have the proper legal authority to step in to take care of you when needed. Simply to avoid that, documents that you can have in place would be a durable power of attorney. Durable power of attorney can give the person the legal authority to take care of your affairs without needing a court-appointed authority. When a petition is filed with the court, you then become a ward of the state. Okay, and it's not, that bell is not easily unrung, meaning that while there's a person that has been designated as your guardian, they have to seek court approval for anything they do with your finances, anything they do regarding your personal care, if they've become the guardian of your person and your property. Sometimes it's just the property, sometimes it's both. So one of the things we want to think about is probably while this has happened, while this is happening, you no longer have the legal capacity to make this decision for yourself, or else you would just get the durable power of attorney done. So I'm just saying this capacity to enter into an agreement is not always a given. You know, you could be in a coma, you could have gotten into a car accident, you know, anything, dementia could have kicked in, you know, just lifing, you know, can happen, and it can deteriorate your mental capacity. So one thing that I'm finding is a lot of times clients are waiting way too long to go ahead and take action, especially if you're a caretaker, right? So let's talk to the caretakers. You are responsible for mom and dad. They're advancing in age. You kind of don't ever want to think about your loved ones not being with you. So you're frozen with fear and you're not taking action, and they lose capacity, meaning that they no longer can sign this very powerful document that could cost you a few $100s and can save you a lot of time, heartache, and consternation. So avoiding guardianship can easily be accomplished with getting a durable power of attorney. Now, here's my caveat to that. Make sure that the documents at a minimum are drafted by a professional or reviewed by a professional, because what can happen is if they're not executed according to your state's guidelines, they're invalid. And probably you wouldn't pull them out until you need them, meaning that something has happened and maybe mental incapacitation has settled in, meaning that the person no longer can sign a new document, right? So the time, and this has happened. I have a case right now where estate planning was done, all types of fancy documents, trust, durable power of attorney, the whole kit and caboodle, but it was not by a seasoned practitioner, and it was not executed according to Maryland rules. And as a result, all of that planning is null and void. And now the person designated to take care of all of the estate affairs is rendered helpless, useless, and would have to go seek a petition for guardianship, can't avoid probate, and get all the wonderful benefits of an estate plan. So executing the document is highly critical. So be slow on the do-it-yourself. At least consult a professional like myself to make sure you did it right, okay? And that it is accepted at the institutions that you're going to need to use them for, especially banks. Banks are very sensitive. So this durable power of attorney, there's a couple other documents I would recommend that you have: HIPAA release forms, durable power, financial powers of attorney, medical directives. These documents help you avoid guardianship, okay? And it allows you to remain the foremost influential person in determining who's going to take care of your affairs. Another tip that I would add, you're going to want to make sure that at least the document has a couple alternates, okay? Don't designate one person like your spouse and then you survive your spouse and then all of your estate planning is useless. We don't want that. Okay, but going back to what if you're not married? Who are you going to have there in your extended, redefined, contoured family? Is it your bestie? Is it your sister? Is it your niece? Is it your nephew? Is it who? You know what I mean? Who is it going to be? And starting to have those conversations, starting to bring them into the fold as to what's in the estate, what kind of help and care you might need, asking them if they have the bandwidth and the capacity and the willingness to step up for you in terms of being, a person that you can rely on in a time of need with regards to a loss of, capacity. This person would be responsible, like yourself, taxes, banking. They can help preserve your property, making sure it's secure, making sure it's safe. You're in a rehab, right? Who's taking care of your house, right? We don't want people squatting in your house, renting out your property on Airbnb, right? Because no one knows what was going on and no one had the legal authority to act. So these are some of the things you want to just think about. Kind of like, women, when we go out, you're like this, who's going with me? Who's going to, take this journey with me to make sure that I have some backup. So we're thinking about that on the long-term care incapacitation situation. Okay. Now, so those are the sets of documents, and this is why they're so important when you do your estate planning. Now, another thing that I want you to think about is the rules of intestacy, meaning that if you don't do anything in Maryland, there's a set of rules that are set up that's going to tell you how your estate is going to be passed along to your heirs. If you don't have children, you really going to want to think about, and maybe you do, and you're still saying, well, I don't want to, I don't know if I'm going to give all my kids all my stuff. You may want to divide your estate intentionally, right? And if you don't have kids, right, even if you do, but say if you don't, I think, well, definitely, I can tell you in Maryland, the first they're going to look, it's going to go to your parents. And then after your parents, if your parents have predeceased you, then it's going to go to your siblings, right? And after your siblings, then it'll move down to your nieces and nephews, and it goes through the family line like that. Now, if you have redefined your family, right, and you have people that are close to you, nephews, nieces, whomever, close friends that you want to leave a legacy to, you're going to have to plan for that, because by default, a lot of times people fall within what the law would think you would want to do, your spouse and your kids. After that, it's a free fall. So you might want to think about organizations. You may want to think about, goddaughters, you know what I mean? Those extended cousins that came into the fold, like nieces and nephews. So this is where you have to be a bit intentional about how you are going to leave your legacy and who you're going to leave it to when the answer isn't that obvious to the law, right? It's the only person that's not obvious to is the law. And you really want to make sure you take some time to think about that. Okay, final tip on this topic was recently I've had this polarizing experience of assisting a woman that is in a nursing home, okay? In a nursing home, and her needing a guardian, right? Went through that process with her. And one of the things I noted is, another tip on that avoiding guardianship is health. I mean, I think that's the most obvious one, because this woman didn't lose her mental capacity. She lost her physical capacity just to, being, carrying a lot of weight, not being mobile. So one of the basic ones I didn't want to avoid is take good care of your mobility. Okay. That is like devastating, that the fact that you just can't get up and walk around and go outside, breathe oxygen. It really has impressed upon me the kind of future I want to have for myself and how I want to take care of myself now. Another thing, the other side of this is I had opportunity to go to one of these really nice, retirement communities. I mean, it was given hotel. Okay. It had, top end chefs. It just seemed like a really nice hotel experience. A lot of community games, a lot of involvement, just really nice. I saw couples in there, they have a community. And it made me think about estate planning in a way, in terms of long-term care, to thinking about maybe if you wanted to be in one of those communities with a spouse or by yourself, because you don't want to possibly live in a house, at some point alone. But, just opening up, just checking it out, seeing how much they cost. I mean, some of these places run between $3,000 and $5,000 a month, and thinking about having investments, maybe, and we don't know how life will end up. We can say a man is not an estate plan, but you may happily get married and live with your spouse and y'all live together in the house. But maybe someone may predecease the other person, definitely, What then? How would you want to be living? And do you have the resources necessary to give yourself the options? It's not making the decision, but making sure, do I have enough revenue coming in from investments, 401ks to fund $5,000-6,000 a month if I want to live in a real fancy schmancy situation where they don't have to cook any food. There's no grocery shopping. The meals are prepared. The rooms are laid out. The facility is brand new. I think it would be at least like 55 to move in. A lot of times people think about, that is an option, but thinking about, do I have the nest egg brewing in some sort of investment tool? It could be your home. It could be that liquidate your home and live here for 10 years, 12 years, 15 years. I don't know. But it's just thinking about these things, especially if you're around my age and you're thinking about, your future many, many years down the road, but then also taking care of loved ones as I, start to think about my parents and things of that nature. So that's what I wanted to share with you today. It's at the top of my mind always, things that I would like for you to know. And I think the takeaway for today is you can easily have estate planning documents put in place to avoid guardianship that don't have to cost you a lot of money, but can save you a lot of heartache and consternation, and and avoid becoming a ward of the state and remaining, having some level of autonomy over who is going to be involved. And you get to make that decision, who's going to be involved in your care, managing your money, managing your day-to-day decision making if that's needed. And it's a stage of life that a lot of people hope that we never have to experience, right? I just want to go home and have been mobile my whole life and then lay down one day and just be restful and peaceful. And I don't want a middle stage, but I'm not calling that shot. So I do want us to have some, grace with ourselves and really just taking a peek and thinking about it, especially if you have to think about who's going to step up for you. And that needs to be written down, okay? It needs to be beyond the thought. It has to be in writing. And we're available to help you, because if you don't write it down and you didn't get around to it, the state, no one, no nephew, no person out of the direct bloodline can come in and convince the court that they was your play daughter, okay? And you was like their mother. They're not going to hear that story, and they will be disinherited. So if you have an intention to take care of someone in that way, please be mindful and make a plan. So thanks for tuning in to the Carmiece Graves show. Thank you for spending some time with me. If you found any of this useful, hopefully you did, that you will share and like and tune in with me again as I come up with these nuggets of things that I think can enrich the community. But thank you so much for your time. I know we're all busy, and I'll talk to you soon. Thanks. Bye.